Generally, an administrative agency's interpretation of an ambiguous statute that the agency is responsible for administering is entitled to great deference by courts. However, this deference, commonly referred to as Chevron deference, isn't absolute. In the 2016 case, Encino Motorcars LLC versus Navarro, the United States Supreme Court considered whether an agency's regulation was entitled to Chevron deference when the agency failed to follow the correct procedures in issuing the regulation. The Fair Labor Standards Act, or the FLSA, requires employers to pay time-and-a-half wages to covered employees who work more than 40 hours a week. In 1966, Congress exempted the overtime compensation requirement for, quote, any salesman, partsman, or mechanic primarily engaged in selling or servicing automobiles, unquote, at a covered dealership. Congress also authorized the Department of Labor, which we'll call the Department, a federal administrative agency, to promulgate rules, regulations, or orders under the FLSA. In 1970, the Department issued a regulation defining salesmen to exclude service advisors who sell repair and maintenance services from the exemption. In 1978, the Department departed from its rule and stated that service advisors could be exempt. But in 2011, the Department issued a final rule that interpreted salesmen to mean only employees who sell vehicles. The Department didn't provide detailed reasons for the change. Hector Navarro was employed as a service advisor by Encino Motorcars, a Mercedes-Benz dealership in the Los Angeles area. As employees of Encino, Navarro and other service advisors were required to work 11 hours a day, 5 days a week. Also, Navarro and other service advisors were paid commissions on the services they sold, and not a fixed salary or hourly wage. Subsequently, Navarro and other service advisors sued Encino in federal district court, alleging that it violated the FLSA by failing to pay them overtime compensation. In response, Encino filed a motion to dismiss, arguing that the FLSA overtime provisions didn't apply to service advisors. The district court agreed and granted the motion to dismiss. Navarro and others appealed to the Ninth Circuit, which reversed in relevant part, concluding that although the agency's 2011 interpretation is entitled to Chevron deference, the decision conflicts with cases from other courts. The United States Supreme Court granted cert.